Hello friends, Mandar here. I'm back with another video. Today I will talk about the letter that some congressman has sent to Secretary Mayorkas and Secretary Blinken. And this has to do with making all the dates current in the visa bulletin for the filing date chart. I'll tell you how impactful this is and also my detailed thoughts on this topic. You might be surprised to hear some of the things that I'm going to say. I'm also going to announce a giveaway, so watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration and lifestyle related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. Now, before we move forward, I'd like to request you to subscribe to my channel. Now, this is the channel analytics that I'm seeing. Not subscribed are about 73% and subscribed are only 27%. So this tells me that a lot of people watch my videos but don't subscribe to my channel necessarily, and it would greatly help to keep me going and keep my motivation going if you can subscribe to my channel. And also there is a reason for this. If you also like and comment, and I'll talk about the giveaway towards the end of this video. Also check out the links in the description because those are affiliate links and you might find something useful for yourself. Now, some people told me that there is a letter that some congressman has sent Secretary Mayorkas and Secretary Blinken, and this has to do with making the dates current in October 1st of 2023. They have sent this letter on July 28th. Now, this is very interesting. Let me read out the letter and I'll talk about my thoughts in detail and tell you different perspectives. You might be surprised to hear those perspectives. Now, here's what they say. The US economy continues to benefit from high-skilled immigrants and so on in the STEM field, and given decades of long backlog and increased recruitment by Canada of foreign STEM talent, the number of individuals who remain committed to waiting for an employment-based green card is unclear. As a result, we encourage administration to make all employment-based visas current on the visa bulletin on October 1st, 2023. So this is the first thing. Now, they claim that the number of people who are actually waiting on pending adjustment of status is unclear, and that is to some extent true because the numbers that USCIS releases is for approved I-140. Now, it doesn't mean that all those people are waiting for the green card, but it does tell that they were all waiting to get a green card at some point. Now, the second thing is, by definition, on October 1st, none of the available 140,000 employment-based green cards have been allocated yet for that fiscal year. Moreover, at the beginning of the year, it cannot be known how many people who have either applied or who will apply for the green cards will actually be eligible to receive a green card. Some numbers will be approved, some will be denied of the many statutory and discretionary grounds of ineligibility. Other individuals may even have lost their employer sponsors due to the recent layoffs in the tech sector or moved to a country with a straightforward immigration law. So what they are saying is, don't restrict the people to apply for 485 adjustment of status because you may not have enough people in the waiting list to allocate your green card numbers for that particular year. So that's what they are saying. Over the past few years, Department of State has been widely inconsistent in how it has set the bulletin, creating confusion among those seeking employment-based green cards. Therefore, all eligible applicants who have an approved I-140 should have the opportunity to submit an I-485 adjustment of status between October 1st and October 31st. So they are saying keep this window open for everybody to apply for 485. This way the administration can ensure that it will have sufficient applicants towards each of these available green cards. Now, their grounds for saying that there are not enough applicants in the pool to issue a green card is somewhat flawed in my opinion. The reason they run out of numbers is because there are not enough visa numbers available. So sometimes EB1, EB2 and EB3, like what happens this year, they have run out of the green cards. It doesn't mean that there are lesser applicants in the pool, lesser pending adjustment of status. It means that the number of green cards were short. But in this, what they are trying to say is that they may fall short of number of pending applicants, which is highly flawed. But anyways, we'll take for what it's worth. They go on to say the way administration can ensure that it will have sufficient applicants towards each of these available green cards, as it has been seen many years prior that green cards go waste rather than issued to extremely deserving applicants. Now green cards have gone waste not because of the shortage of pending applicants, they have gone waste because of the processing time by the USCIS. There is a historical precedent to utilizing Visa Bulletin to gauge interest in green cards, such as when President George W. Bush and his administration marked all dates as current in July 2007 Visa Bulletin. Yes, that has happened in the past. If you remember, people who have been around during the 2007 time frame, all the dates were suddenly made current in the July 2007 Visa Bulletin. That allowed everybody to apply, everybody who had an approved I-140 to apply for 485 and also apply for EAD and AP card. Now this letter is incredible because this has not happened in the past, at least to my knowledge, and a lot of congressmen are emphasizing that this does not necessarily require a congressional action, but this can be done by USCIS or Department of State on their own. So that is an important point to consider. So this recommendation could possibly be taken into account by USCIS or DHS and actually be implemented easier than having to go through a congressional approval. So that is the good news. So it has a high likelihood of passing, or it has a high likelihood of adoption. Now here are my thoughts about this. Now if they make all the dates current in the filing date chart. Now why filing date chart? Because filing date chart is the chart that USCIS allows people to use for filing of I-485 starting October of every year. They also continue to allow to use the filing date chart up until December or even January. So there is a window of opportunity for people to apply for 485 during this time frame based on the filing date chart. Now what this letter is asking is, keep this filing date chart open to everybody, make everybody's date current, EB1, EB2, EB3, everybody, entire chart should be current, so that maximum number of people who have an approved I-140 can apply for their 485, which is adjustment of status. Now what will happen is, now during that month, if people apply for 485, regardless of what is the date in the final action chart, they will be eligible to get a EAD and AP card, because those can be those also can be applied concurrently. Now with EAD, there is an advantage because you are not employer dependent. You can change your job, you can do multiple jobs, you can do business, you can sit at home, not work, and so on. That is one important thing. And also advanced payroll will allow you to travel outside of the United States and come back without having to worry about the stamping. Currently the H1 stamping is the most painful thing for people who are on H1B on extended period of time. So this will be a great relief for people who will be waiting for decades to actually get their green card, but in the meantime they will have their EAD, they will have their flexibility to change the job, and they will also have the flexibility to travel outside the US without worrying about the stamping process. So that is the biggest benefit. If you can imagine, for the backlog countries whose priority dates are anywhere from 2012 up until 2023, everybody will be able to apply for their 485, get into the adjustment of status, and avail the EAD and AP benefits. So that will be incredible. Now it will also mean that the filing date chart will become irrelevant. Now what's not to say that the next letter that the congressman will say that make this filing date chart irrelevant or just remove it, and that was the call I have seen and some of the news on the Twitter. If USCIS removes this filing date chart, then it will be like everybody's dates will be current every time. So anybody who can apply for an I-140 can concurrently apply for 485 and get their EAD and AP. Now that doesn't mean that you will get a green card. For the green card you will still need to wait for your visa number, and that will be reflected in the final action chart. That's when your actual green card will be processed. So it might take couple of months, couple of years, or even decades, but in the meantime you are at least on adjustment of status and having your EAD and AP to avail. Now this is, I am saying, on the pretext that they might get away with filing date chart. If they are asking for the visa bulletin to be current for 1 month, they might as well ask for making it current forever. Why not, right? Just remove the filing date chart. Now here's my another thought. That would mean, if that happens, it will also mean that the non-immigrant or most of the non-immigrant visas will become irrelevant. Now you will be surprised to hear this, but let me explain. The reason people need to remain on non-immigrant status such as H or L is because they need to maintain the status in the United States even though they have an approved I-140. Now if they open this window for allowing people, everybody to apply for 485, then those people will immediately go into an adjustment of status. It's a period of authorized stay for anybody who has applied for adjustment of status. So in that case, nobody will need an H or a L. So imagine if you have a 140, if you have a approved 140, and if they allow you to apply for 485, you will not have to worry about your status, because merely by the fact that you are pending on adjustment of status will provide you a valid status to remain in the United States. Your EAD will provide you the work authorization. So why do you need H or L? The adjustment of status will be your new permanent status. No visa needed. So you come in the United States on any visa, you get an employer to apply for your perm. As soon as your perm is approved within a year, you can apply for 140, 485, EAD and AP all at once. You never ever have to worry about your status in the United States. Doesn't matter if it takes 10, 20, 30 years for you to ultimately get your green card, you'll always remain in the status, because you'll always remain in the pending adjustment of status. You will avail advance payroll for traveling, and you will avail EAD for your employment authorization. It will be like having a green card without the green card. Now I have some more interesting points, but let's look at the sponsors video and I'll talk about them right after. So I know for sure that some of you are interested in stock trading, day trading, buying cryptocurrencies. I want to present you Weebull. Weebull is a trading platform. It allows you to buy stock, it allows you to buy options, do options trading, and also it allows you to buy cryptocurrency. Weebull 9 was released with a brand new home and market page, asset page, and economic calendar. Also, Weebull Cash Management was launched with 5.8% API with no fees attached and no minimum balance and unlimited withdrawals. This is amazing. New Weebull USA users can still enjoy 5.8% APY and get up to 12 free stocks when making an initial deposit of each is valued between $3 and $3,000. Feel free to take advantage of this. Join through my link and you will get those free stocks. Now with this current priority date, in the filing date chart, everybody is eligible who has an I-140 approved will be eligible for adjustment of status, right? That status will essentially provide you unlimited status until you get your green card. So essentially you are in status from now on for the rest of your life. Isn't it amazing? Now this will also mean that there will be unlimited flow of immigrants to the United States for the sole purpose of obtaining EAD and AP based on adjustment of status. Now how is that possible? Essentially, your adjustment of status and your EAD and AP will be a proxy green card. It will essentially give you the freedom to live in the United States without a visa, work without any employer restrictions, and travel without ever having to worry about the stamping. So you'll never need a non-immigrant visa. In this new reality, green card may not be relevant anymore because the new de facto green card will be EAD card and status on your pending adjustment of status, because it essentially gives you everything that green card will give you right after your I-140 approval. Now there is a downside to the lawyers because they will miss out on these fees of H-1B extensions and amendments and so on, transfers and so on. Because to file the EAD and AP, you will not need a lawyer. It is a simple, straightforward form that you can fill out anytime. And if they allow the premium processing for EAD and AP, you are at ease because you don't have to worry about the long processing times. You just fill out the form, submit the fees online, and you will get your EAD AP within a couple of weeks. And that's coming to my knowledge. So if this letter that is being sent by Congressman to the secretaries is implemented as policy, make all the dates current on every October from 1st of October to 31st of October, that will be a de facto green card to many people, and it will encourage a lot of immigrants from these backlog countries to come into the United States and stay in this ever long backlog for green card, but not having to worry about getting a green card because you are getting all the benefits of green card. You can live status free, you can work on EAD, and you can travel with AP card. Who cares if the green card comes after 20 years, right? So that is what might happen. Now you might say that it's not that easy, but let me run you through a couple of scenarios and you'll see why I'm saying this. Now let's take an example. Say you are a student coming from India, right? Currently, if you come as a student on F1 visa, you will still have to go through the OPT, you will still have to go through the H1B lottery and then apply for the green card. And then even if you apply for the green card, you will have to continue to maintain your H1B status until such point as your priority date becomes current in the filing date chart, right? So that is the current process. Now in this new world, what you can do is you can come on the student visa, F1 visa, and towards the end of your F1 visa, when you are on OPT, you can ask your employer to file your perm and I-140. And even before your OPT expires, you will have your I-140 approved, and immediately you can apply for 485 and EAD and AP. You will never ever have to apply for your H1B. You can skip the entire non-immigrant status or H1B lottery program. Isn't that amazing? Now let's say there is a second scenario. If you don't want to study in the United States, you just want to come here or get your EAD. What you can do is you can apply for your B1, B2 visa. In the past couple of months, they have already said that if you are on B1, B2, you can still apply for your job. You cannot start your job, but you can apply for your job. As soon as you get your job, you can ask them to apply for your perm and I-140. Then you go straight to I-140 approval and 485 and EAD. Skip all the L1 and H1 crap. You don't have to apply for that. So you come on B1, find out your employer, ask them to apply for your perm because that is for future employment. And you have to be in the United States while you apply for your I-140 and 485, because you can apply for 485 only when you are in the US and you are in the US on B1, B2. But after coming here, people change mind after 90 days, right? Or in the third scenario, if you have masters or PhD from India, directly apply for EB1 and apply for 485 directly. If this recommendation is accepted by the USCIS, people will have an opportunity to get into the EAD or get into the pending adjustment of status by skipping the entire non-immigrant visas. So these were my thoughts. Put down in the comment section below what you think about it. Do you agree with my thoughts or do you not agree with my thoughts? Also put down in the comment section below if you think that this recommendation will be accepted by USCIS or not. I'll love to hear your comments. And by the way, I am starting a new giveaway. The rules are simple. Number 1, you need to subscribe to the channel and put in the comment section that you have subscribed, and also add some meaningful comment in the relation to the video. Second, also like the video. So subscribe, comment and like this video and all subsequent video leading up to middle of September. That's when I will be doing a big giveaway. It will be a new Apple Watch that will be coming in September. People who are already the subscribers, you don't have to worry. As long as you comment and like, you will be entered into the draw. So that's really all I wanted to say in this video. If you like the content of this video, do hit the like button and consider subscribing to my channel, and I'll see you in the next one.